Okay, last case on the docket is Department of Highway Safety and Motor Vehicles versus Johnson. Let me reset the clock just a minute. Okay.
Good morning. May it please the Court, I'm Tim Osterhaus, Counsel for the Department of Highway Safety and Motor Vehicles. I'd like to reserve 5 minutes for argument. Our appeal asks this Court to recognize that a single subject defect in a law is cured when the legislature adopts it as an official Florida statute. In 1998, the legislature enacted the statutory amendment at issue here, 98-223 Florida laws, that in part address the parameters for getting a driver's license back after it had been revoked. It removed the ability of 4-time DUI offenders to petition to get their licenses back. In 2002, this Court in the Critchfield case found this law to violate the single subject requirement of Article 3, Section 6, because it addressed not only driver's license, but also the passing of worthless checks. In fact, its short title was an act relating to worthless checks. The Florida Supreme Court subsequently affirmed and issued an opinion finding along the same line that these subjects were too dissimilar for a single law. Notably, however, this Court's Critchfield decision appeared to suggest that the law might yet be cured when adopted as an official statute, and indeed that's what happened in 2003. The legislature reenacted the law 98-223 as part of its adoption of the 2003 Florida statutes, so it officially codified that law. So today the issue that divides us, the parties here, is whether the 98 law and its single subject defect was cured by the 2003 reenactment, notwithstanding the intervening Critchfield decision. As a preliminary matter, the first, second, and fourth DCAs have addressed this law and deemed it to be cured by the 2003 reenactment. However, here
if we say it's cured, does the statute relate back to when it was originally enacted, or does it become effective when it's reenacted? In other words, if the legislature reenacts a statute that violates a single subject rule, does the reenacted statute become retroactively effective to the date that it was enacted before, or does it become effective the date that it's reenacted?
Yes, our position is that as of the cure date, as of July 1st, 2003, that the cure is in effect, and during that intervening period, in this case about a 5-year period, that opens a window period so that offenders that apply to get their licenses back during that window period may have their petitions considered.
And how long was the window period in this case?
In this case, the window period ended on July the 1st, 2003. So essentially, anything before that date would relate back to the 97 statute, because the law was declared invalid.
Did Mr. Johnson, or did he or didn't he fall within the window period?
Mr. Johnson did not, because he didn't apply to get his license back until after July 1st, 2003. I believe his fourth DUI and his license was revealed actually 10 years previously in 93. However, his application to get it back did not arise until after 2003. The Ninth Circuit ruled that the Critchfield case essentially rendered the law void ab initio, essentially that it could not be revived or cured because the law is considered to be as if it never existed. Its conclusion was based on a handful of cases that used this term void in the context of a court finding a single subject defect. Cases like the Higgs case, the Jones case, which was a 5th District case, the Green case, and Williams cases that the court relied on actually didn't didn't address at all the cure, the application of the cure. Instead, in the Jones, Green, and Williams' case, those cases involved whether already cured laws could be retroactively applied. And in the case of the Higgs case, the premise, again, was the law had already been cured, and there was a disagreement, I guess, or the issue was what the relevant window period was when the cure essentially took effect. The Second and the Fourth DCAs had a disagreement on that issue. This whole idea that whether a law is deemed void, as this term has been thrown around, it doesn't necessarily impact whether a law can be cured by its subsequent reenactment, is well seen in the Tormey case. This was a unanimous Florida Supreme Court decision in 2002, where in one sentence the Florida Supreme Court recognized that the law was void, but in the very next sentence it talked about the laws being cured as of a certain date. So all to say that just because a law is rendered void, that does not preclude a subsequent cure when the law is reenacted into the Florida statute books. And for what it's worth, in the Critchfield case, neither this court or Florida Supreme Court actually deemed this particular law to be void, but talked about it as being invalid. We think that the Badgett case is controlling here. This was the 1945 case. And since this time, and even before, it's been the position of the Florida Supreme Court that a single subject effect is cured when it's reenacted in the Florida statutes, irrespective of whether there's an intervening adjudication or not. The same ruling came out of the Thompson case in 1952, where the Florida Supreme Court stated, and I quote, "There's no reason to discriminate between laws that had and those that had not been adjudicated unconstitutional." The appellees try to distinguish the Badgett and Thompson lines, the rules of those cases, by saying that those were title cases. Those didn't have to do with the single subject, one subject requirement, which there are two prongs to the Article 3, Section 6 single subject requirement. It requires that a short title address what the law is about, and it requires that the law address just a single subject. But Badgett itself sort of clarifies what it's talking about when it talks about the Badgett case discussed. It involved a title defect, but it also involved a couple of other constitutional claims there, that the law was unconstitutionally arbitrary, and the third claim was that the law was unconstitutional. It was an unconstitutional restraint on competitive bidding. And the Badgett court discussed that the title defect was essentially a defective form that could by application of the codification rule, could be corrected by its subsequent reenactment, because it was a form related defect. However, the latter two claims, that something's unconstitutionally arbitrary or unconstitutional restraint on competitive bidding, those went to the very substance and content of the law. And therefore, whether you enact that or reenact it again and again, because you're talking about the content of the law, reenactment really is unavailing. It doesn't do anything. Here, the one subject defect that is at issue is much like the title defect in the Badgett case, because it has to do with form. The legislature needs to use the correct type of form, both in the title and as to just addressing one subject within a law. To the extent that they don't, the law can be rendered unconstitutional because of that form. But then when they subsequently reenact it, the rule in Florida is that law becomes cured. Finally, we think that the Tormey case is also a helpful one to look at. I referred to that case earlier, and it's cited in all the briefs here. That's a 2003 unanimous Supreme Court case where a law not only had a one subject defect but also a title defect. And the Florida Supreme Court said there that the general rule is that a single subject violation, whether it be, again, title or the one subject defect, is cured when the legislature reenacts the provision as part of its biannual readoption process. I'll reserve the
Okay.
Good morning. May it please the court. My name is William Pinnell, and I represent the appellee David Johnson in this case. The underlying case in this matter is the Critchfield decision, in which the Florida Supreme Court ultimately concluded that Chapter 98-223 violated the single subject rule contained in Article 3, Section 6 of the Florida Constitution. In that case, Mr. Critchfield, who was also represented by our law firm, was successful in every court in which he litigated. The Circuit Court, this court, and the Florida Supreme Court all concluded that Chapter 98-223 violated the single subject rule. It was more than 3 years of litigation.
Let me ask you just to see if there's any dispute here. And I'm not saying how we're going to rule, but I'm just asking you, if we say that it was cured by the subsequent reenactment, my question to you is there a window period, and what is the window period? Did your client fall within the window period? I think he said the window period was, didn't you say July 1st, 2003?
That's correct.
Is there any dispute about any of that? Or, I mean, if we say that there was a reenactment and that cured it, and he said the window period was July 1st, 2003, do you agree or disagree with that?
I believe that would be the date that the window period would have closed.
Okay, and if we say, and I'm not saying how we're going to rule, if we say that there was a cure, did your client fall within the window period, or did he fall outside of it?
He fell outside.
I'm sorry, outside.
Outside.
Of it? Okay. Okay, go ahead.
There was more than 3 years of litigation in the Critchfield matter, and if you accept the department's interpretation of the law, after all that litigation, there would only be actually a 19-day window period where the chapter law in question would be invalid. The department contends that Chapter 98-223 was declared invalid on June 11, 2003, when the Supreme Court denied rehearing in Critchfield, and was cured on July 1st, 2003, when the subsequent chapter law, 2003-25, took effect. That's a general reenactment bill which only contains a few sentences and makes absolutely no mention of Chapter 98-223 or any of the subjects discussed in that law. It's our position that the department's interpretation of the law would eviscerate the constitutional protections afforded by the single subject rule and Article 3, Section 6 of the Florida Constitution.
Is it your position that what you would look right now in the Florida statutes and find for Section 322.282E is not valid? Is not a valid statute right now?
The Section 322.282E is valid, and that indicates that a person who receives 4 DUIs is permanently revoked. The section in question that was modified by Chapter 98-223 was 322.271 subsection 4.
All right. Are you saying that is still in the statutes?
I believe the 1997 version is currently in effect.
All right. But if you looked up Florida statutes now, you wouldn't find the 1997 version.
If I went on Westlaw today or looked in my statute book, I would see the new version.
All right. Are you saying that the readoption or attempted readoption by the legislature in 2003 didn't accomplish anything?
That is what we're saying. We are saying it did not reenact any of the provisions of Chapter 98-223, including the purported amendment to the 322.271 subsection 4.
Then how would you respond to your opposing counsel's argument that in Critchfield, that same Critchfield opinion you referred to also contains language that once reenacted by way of an adoption action, as a portion of the Florida statutes, a chapter or session law is no longer subject to challenge on the grounds that it violates the single subject requirement?
It's our position that reenactment would have to occur prior to a decision of the Florida Supreme Court or prior to a litigant filing the claim that the single subject violation occurred. Because to hold otherwise would eviscerate the Article 3, Section 6 protection that is in the Constitution and protects the public from log rolling and the other problems that are addressed by the single subject rule that was placed in the Constitution. Here, again, as I indicated initially, there was only a 19-day window period if you accept the department's contention that the rehearing denial was the date that the decision was declared, the chapter law in question was declared invalid. So if you accept the department's position, you give the courts the ability to recognize a problem, but don't give them any power to craft a sufficient remedy. So it's our position that this court should reject the department's interpretation and conclude that the single subject violation contained in Chapter 98.223 has never been cured. The department indicates that it believes this case is controlled by the Badgett versus Lee decision from the Florida Supreme Court back in 1945. And that case does indicate that an act with an insufficient title can be cured by a general revision reenactment, whether the single subject issue has been adjudicated or not. It also indicates that incorporation to general revision does not cure unconstitutionality of content, only mere title defects. We believe that the defect in this case is not a title defect, but it is a defect of content. This court and the Supreme Court has indicated that the content, because it had two different subjects, rendered the statute invalid. So we believe this is an issue of content and is distinguishable from the Lee case.
And that would make every statute that was declared invalid for violation of the single subject rule invalid based on substance and content rather than the title, wouldn't it? I mean, if I understand your argument, you're saying that because it was co-joined with in another chapter with another statute, that it made it a matter of substance rather than title. Is that basically what you're saying?
That is what I'm saying, and all the cases...
If that's the case, then what instance would there be when, a statute would violate the single subject requirement and be based on title rather than substance?
Well, the three cases cited primarily by the state are the examples we would rely on. The Badgett case, the Thompson case, and the McKee case all indicated that there were title defects, not multiple subjects in the content of the bill. The courts have consistently indicated that there's two different parts of the single subject rule, one dealing with an inadequate title and one dealing with chapter laws that have more than one subject.
So, I mean, I think I'm starting to understand your argument. Your argument is that if there are two subjects in the title, as opposed to the statute being conjoined with other statutes and that sort of thing, that makes the difference?
That's part of it. If the title was inadequate because it had two subjects right. If the title was inadequate because it didn't adequately state the subject or had two subjects in it, it would be different than if there's two subjects in the body. And the reason we say that is first, there's no Supreme Court opinion that applies the rule laid out in Badgett to a case where the chapter law contained multiple subjects. The department has not cited one, and I have not found one where they have applied the Badgett reasoning to a case that's already been adjudicated and allowed reenactment after that adjudication where there were multiple subjects in the bill.
So you're saying that the chapter law contains multiple subjects, and the court says that it violates the single subject rule, and in that instance, it's always a matter of substance rather than title.
Correct.
Oh.
And that the only way to cure it is to start the bill all over again on just that subject and not to do a reenactment.
Correct. The legislator would have to separate the two different subjects into separate bills and pass them that way, and that would cure the reenactment. And there is some precedent for that, and the legislator would have been aware of that remedy based on the Martinez versus Scanlon case, where the Florida Supreme Court said that was a proper way to cure a single subject defect. Would also point out that it's our position that a single subject violation for a title defect is different from a single subject violation involving two unrelated subjects, because the title doesn't become law. The subjects in the bill actually become law and later can become statutes. So we believe that the constitutional protection in Article 3, Section 6 is more important when there's two unrelated subjects contained in the bill as opposed to where there's a problem just with the title. The Department indicates that the Jones decision, which was reached by this court in 2004, on a motion for rehearing en banc and joined by the entire court, didn't really address whether there was a cure. And that's true, but the court did unequivocally indicate that legislation passed in violation of the single subject rule was not constitutionally enacted, never actually existed, was never on the statute books, and never a part of Florida law, and declared such a statute to be void ab initio. The Green decision from the second DCA reached the same conclusion, and they indicated that the single subject rule is a protection against law growing, and it's meant to ensure that legislation is passed by a majority of the legislators, and that when there's a single subject violation, you assume that there was not a majority. And Judge Altenburn, in that case in the concurrence, indicated his belief that the biennial reenactment is the ultimate act of law growing and should not have a curative effect. The Rothhauser court from the second DCA ignored the prior decision in Green and found that there was a cure, but they did so reluctantly, and I believe the second DCA got it wrong. They rely on the Badger decision like the department is. Without much discussion, they just pretty much accepted as fact that that's controlling, and I think one of the reasons they did so, and I think it's a fair reading of the opinion, is that the attorney for Mr. Rothhauser in that case also indicated his belief that the second DCA was bound by Badger. So we don't believe there was any argument to the contrary in that decision that the DCA was not bound by Badger, and believe for that reason the second DCA got it wrong, and that this court should issue a decision contrary to that court's decision. As I indicated, the court reluctantly found that there was a cure in that case. They noted that the wholesale reenactment of laws is the ultimate act of law growing, and that allowing a cure through that process doesn't really address the main evil that the single subject rule was enacted for, which is law growing. The court in Rothhauser said if the law unconstitutionally enacted in violation of the single subject rule is void from its inception, the only potential way to cure it is through reenactment of separate bills with separate subjects. This court in Jones already indicated that chapter laws passed in violation of a single subject rule are void ab initio. So based on the reasoning in Rothhauser and that conclusion in Jones, this court should conclude that the Chapter 2003-25 passage did not cure the defect in Chapter 98-223. It's our position that Chapter 98-223 was rendered void ab initio as of March 13th when the Florida Supreme Court issued its opinion in Critchfield. As of that date, the contents of the law no longer existed, were not on the statute books, and were not part of Florida law and could not be reenacted through a general reenactment bill. As Judge Evander has indicated, we believe that the only way the contents of Chapter 98-223 could be constitutionally reenacted following the Critchfield decision was for the legislator to separate out the different subjects and pass separate bills with the different subjects. Since that has yet to occur to this date, it's our position that Chapter 98-223 has not been reenacted, and that the 1997 version of 322.271 subsection 4 remains in effect, is the controlling statute in effect today, and for that reason this court should affirm the decision of the trial court. Finally, the one last issue, the department relies on the Torme decision, and we believe that case is distinguishable from the instant case because the cure in that case, the alleged cure in that case occurred 10 years prior to the Florida Supreme Court reaching its decision, and we believe that makes it distinguishable and is different from this case where the challenge and the Florida Supreme Court opinion both predated the alleged cure. So we believe this court should affirm the decision of the trial court. Thank you.
Thank you. 5 minutes and
Thank you.
44
Yeah, just a
seconds.
couple of brief points. First of all, the appellees suggest that the 1997 version of the statute is currently in effect. Well, in 2003, with the readoption of the statutes, what an adoption act does is it not only brings forward all the new laws in the prior statutes, but it repeals everything that's gone previously. The law is repealed, all the previous statutes are repealed. We had one of these in 2003, 2004, 2005, 2006, now 2007. So to suggest that the 97 version of the statute is in effect, it just can't be. It's been repealed five times over. Secondly, as to the Martinez case, the appellees suggest that there is a way to reenact this statute. Despite its being void, there's a way to reenact this statute. But whereas the law has provided for two ways traditionally for statutes to be reenacted, either through the general biannual reenactment process or by separating out the parts. That was circa 1980 in the Martinez case. The appellees latch on to Doesn't it make more sense to require that it be done the second way as opposed to annually repealing and readopting? I mean, doesn't it make more sense to do it the second way? If it's a single subject violation, that way you know what the legislature is intending to do specifically by reenacting this specific statute. Well, I guess my response to that is that the legislature is taking an affirmative step to reenact the statutes through the biennial readoption process.
Yeah, I know, but
yes,
that's just a blanket. I mean, that covers everything, really.
It does.
If you do it individually and require them to do it individually, it would seem to make a little more sense.
Well, I could see a policy along that line as making more sense or being preferable. However, the rule in Florida has been for the last 100 so odd years that we recognize this codification rule. And Judge Altenbrand did a good job at explaining all that out in the Rothhauser case and how he seemingly preferred that we might do it the other way. However, the law is what it is, and I think for good reason. Because with the codification rule, you do get that notice effect is. The log will, essentially what we want to do is we want to lift the proverbial cloak off the legislative process. We want everyone to have notice. We want the legislature to have notice what it's voting on. We want the people to have notice so that they can inform the legislative process. And what happens with the codification rule is that it establishes this curing period. The preface to the Florida statutes, any volume explains this very well, but you have this curing period where we say, well, legislature, if you failed to jump through the appropriate hoops and you failed to give the notice that we like as far as a title on one subject, then during this curing period, we're not going to recognize that law. However, once you readopt it, we're going to assume that everyone has had fair notice of that law. And I think that it also gives some certainty to the law that 10 years, 20 years, 30 years later, people still aren't making single subject defect arguments and allows for judicial administration to be advanced. Thank you.
Thank you both very much. That concludes our session for today.